Yes, good evening to the aspirants of the Law PG Law Set 2022 and conducted by the Osmania University that we are dealing today. The two acts, one is the Copyright Act, another is the Patent Act. Now you read what I posted on the screen. Anyone can unmute and read. Anyone can unmute and read what I posted on the screen. Especially
intellectual property law. Sir, intellectual property law.
You could see only that one. You could not see the good evening. Assalamu alaikum to the aspirants of the PG Law Set 2022.
Assalamu alaikum to the aspirants of PG Law Set 2022 patent.
Worldwide PA 9909287. Then the intellectual property law. Then my address is there. Is it or not? Say yes.
Yes. Yes, sir.
So without wasting the time, first my deal 10 questions. Later I will give to my partner, the host, Kolikonda Sharad Babu. Yes, PG Law Set 2022, University College of Law, Osmania University, Copyright Act 1957 and the Patent Act of 1970. Multiple choice question, that is MCQ, which is initialism. Now let us go to the point of the first question. Of course, I made the I capital AQ. What is the capital? Copyright Act 1957 protects A option, original literacy, dramatic, B, musical and artistic work, C, cinematographic films, sound recording from authorized users, and D, all of the above.
Sir, option D, sir, all of the above.
You said very clearly. It is it will protect the original literary work, no doubt, dramatic work, no doubt, musical and artistic works, then is cinematography films, yes, sound recording from authorized users or unauthorized users.
That should be corrected, sir. Unauthorized users.
That means all the above is not correct. Am I right?
Yes, yes.
Am I right? Say yes.
Yes. Yes.
So, cinematograph, films and sound recording from unauthorized users. Then all of the above is right. Is it clear?
Yes,
sir.
Next, question 1B, capital B. Unlike the case with the patent, copyright protects the expressions and not the dash. A, intention, B option, plan, C, ideas, D, gossip.
Sir,
ideas.
Ideas is the correct.
Ideas is the correct. Is it?
ideas, sir. Yes, sir.
Not the gossip.
Yes. No, not gossip, sir.
Not the gossip. Can the
No,
gossip will be patented, copyright?
No,
No,
sir.
sir.
At that instant, which is the right answer?
C, sir,
C
ideas.
is the right answer.
And ideas are there, no doubt. Ideas are protected over there. Gossip is not protected. Gossip is not protected.
Not protected, sir.
Sir, actually in Copyright Act, it is said about ideas.
Yes, but I changed it a little here. Unlike the case with the patent, question you will read it. Unlike the case with the patent, copyright protects the expression and not the means
Not the intention, sir.
Not the gossip, sir.
not the gossip. I mean, other intention is there, plan is there, ideas are there. Is it clear?
Yes, sir.
Yes, yes.
I put the not. There is no copyright in an idea. In an idea, there is no copyright.
It has
But
to come
gossip
into real
also,
world, sir.
I don't think the gossip also will be coming to the picture.
No, sir.
It will not come into the picture. That means ideas will not covered in the copyright and the gossip will not be covered. But plans and intentions are covered. Is it clear?
Yes. Yes, sir. Yes.
Then the question 1C. The Copyright Act 1957 provides A, administrative remedies, B, civil remedies, C, criminal remedies, D option, all of the above.
Sir, D, sir, all of the above.
It is all of the above is the right answer because it is the administrative remedies, civil remedies, criminal remedies also. Yes, the second question, the Copyright Act 1957 does not provide protection to A. Original literary work. B. Original dramatic work. C. Idea or concepts. D. Original musical work.
Option C, sir. Ideas or concept.
Ideas and concept will not covered in the Copyright Act of 1957. Third question. According to the Copyright Act 1957, author in the case of a cinematograph film, A. the director, B. the producer, C. the distributor, D. the writer.
The producer, sir. Option B.
Option B is that in the case of cinematography, according to the Act, yes,
Once it is sold to distributor.
yeah,
No, sir. It is for producer only.
Author. I said author.
Oh yeah, yes. Sir.
Even if it is sold to distributor also, the ultimate right lies with the author only.
Okay, sir.
But in some cases, director, producer, and distributor is the same, and the writer.
Yes, sir.
Okay. Is it not?
According to Copyright Act, it is the producer.
Okay. According to the Copyright Act, it is the producer. Okay. Next, fourth question is, what will be the territorial extent of the assignment if not specified in the assignment? A. To extend within the whole of India. B. Option to extend within the Commonwealth countries. C. To extend within the whole world. D. Option to extend within the whole universe.
Extend to the whole universe, sir.
Option A is the correct answer. To extend within the whole of India. When it is not specified, then the territorial extent will be only within the whole of India.
Is it clear?
What trips and VPO covers, sir?
It's not specified in the assignment.
Okay.
When it is not specified in the assignment, then generally it extends only within the whole of India.
If it is specified, then
according to the specification, it will be applied.
Okay. The whole universe or world?
The whole world.
Okay.
The universe is not there in the whole world.
Okay, sir.
Shall I proceed?
Yes, sir.
Yeah, fifth question. There is no copyright on option A, music, option B, drama, option C, news, option D, novel.
News, sir.
Option C, news.
It is obviously, if you just apply your brain, then you can say the news copyright will not be there. Sixth question. Copyright currently lost for A. 100 years from the beginning of the calendar year next following the year in which the author dies. B. Option 60 years from the beginning of the calendar year next following in the year in which the author dies. C. 55 years from the beginning of the calendar year next following the year in which the author dies. D. All copyright eligible works created on or after January 1st, 1978 are protected for the 70 years after the death of their author.
Option B, sir. 60 years.
Option D, it is say that 70 years when January 1st, 1978, on or after. Then the 70 years after the death of their author, the copyright will be holds good. Is it clear?
The answer is D, sir.
Answer is D.
Okay, I thought it is 60. Okay.
I say January 1st on or after January 1st, 1978. It is made to the 70 years after the death of the author. Is it clear?
Okay, sir. Okay, sir.
Yes.
Seventh question. In the copyright production, the registration is, our goal should A. compulsory, B. option not to be done, C. be done, D. optional.
Optional, sir. D.
It's the D is optional, it's not a mandatory.
Yes, sir.
Eighth question. A copyright is a collection of the exclusive right which are vested in the owner of the copyright according to dash of the Copyright Act 1957. Option A, Section 14. Option B, Section 10. Option C, Section 13. Option D, Section 16.
Option B, sir. Section 10.
Wrong.
Sir, option C, section 13.
Wrong.
14.
Option
A is the correct.
Section 14 is the right answer. For the 8th question, option A, section 14 is the right answer. Is it clear?
Yes, sir. Yes, sir.
Yes.
Good. 9th question. According to Dash of the Copyright Act 1957, the author or the creator of the work is the first owner of the copyright. A, section 21 says, B, section 15 says, C, section 18 says, D, option section 17 says. Which section of the Copyright Act 1957, author or the creator of the work is the first owner of the copyright?
A section 21, sir.
No. The right option is D, section 17.
Section 7.
Section 17 says of the Copyright Act of 1957, the first is the person who is the author of the 10th question. The Government of India has, by virtue of the dash, extended copyright protection to works first published outside India. A option, International Copyright Order 1996, B, International Copyright Order 1999, C option, International Copyright Order 2000, D, International Copyright Order 2022.
So option B is an International Copyright Order 1999.
1999, the B is the right answer. International Copyright Order of the 1999 is the right answer for the 10th question. Now I will shift on to our teammate Kolikonda Sharad Babu to continue from the 11th question.
Okay, sir. Good morning, all of you. The first Copyright Act of India was enacted in dash during the reign of the East India Company. A, 1860, B, 1867, C, 1847, D, 1845.
1847.
Yes, 1847 is the correct answer.
The C is the right answer.
Option.
Right.
Yes.
1847. Okay.
Next.
Continue.
Question. The civil remedies for copyright infringement are covered under dash of the Copyright Act of 1957. A, section 54, B, section 58, C, section 59, D, section 55.
D section 55.
Yes, D is the correct option. Section 55. Copyright infringement are covered civil remedies. Now, 13th question. The criminal remedies for infringement of copyright are provided under dash of the Copyright Act 1957. A, section 60, B, section 63, C, section 65, D, section 69.
Section 63, sir. Option B.
The option B is the correct answer. Section 63 that attracts criminal remedies for infringement of copyright. 14th question. The criminal remedies for infringement of copyright do not include A, damages, B, seizure of goods, C, fine, D, imprisonment.
So seizure of goods.
Fine, sir.
That obviously is a criminal remedy.
It's not. Do not include. Yeah. Fine, sir. Fine.
Damages, A. A is the correct option. Always damages are not covered under civil remedies. They are only criminal remedies. They are only civil remedies, damages. So option A is the correct answer. 15th question. Dash brought the Indian copyright law into compliance with the World Intellectual Property Organization Internet Treaties, the WIPO Copyright Treaty, WCT, and WIPO Performances and Phonograms Treaty, WPPT. A. The Copyright Amendment Bill 1983, the Copyright Amendment Bill 1984. C. The Copyright Amendment Bill 1999. D. The Copyright Amendment Bill 2012.
Sir, 1984, sir. Option B.
Second option.
Option D is option D is the correct answer. The Copyright Amendment Bill 2012.
Okay.
2012.
Okay.
Next, copyright is A or an A, tangible property, B, limited property, C, intangible property, D, unlimited property.
Option C, sir. Intangible property.
Yes, option C is the correct answer.
What is meant by intangible property?
Which cannot be
Cannot be
seen.
seen.
Which
Abstract.
cannot be touched.
Abstract. Cannot have physical form. Which cannot be touched.
Yes.
Yes. Next, 17th question. The covenants that provide to frame present rules and laws of the Copyright Act are A, Berne Convention and Toronto Convention, B, Berne Convention and Geneva Convention, C, Berne Convention and Rome Convention, D, Berne Convention and Paris Convention.
Sir, option B,
D, sir.
Berne Convention and Geneva.
Sir, C, sir. Berne
Next
Convention
option.
and Rome Convention.
Yes, C, option C is the correct answer. Berne
Supplementary
Convention
question.
and Rome Convention.
Supplementary question.
In both,
Whenever you are writing the thesis, dissertation, there you mention the Berne Convention only.
Yes, sir.
Okay. Yes.
Next.
next 18th question. One of the following is renowned as judicial champion of rights of authors. A, Lord Chelmsford, B, Lord Mansfield, C, Lord Chesterfield, D, Lord Dixon.
Option D, sir. Lord Dixon.
Second option.
So,
There
Lord
should be
Chelmsford,
D,
sir.
sir.
Yes, sir.
Option
B,
B is the
Lord
correct
Mansfield.
answer.
Lord
Lord
Mansfield.
Mansfield.
Yes.
He is the judicial champion of rights of authors.
Sure.
Next, 19th question. The Act number of Copyright Act 1957 is A 14, B 23, C 15, D 32.
32, sir. It's option D.
Second option.
Option,
14, sir.
yes, option A is the correct answer, 14. The Act number of Copyright Act 1957 is 14. So option A is the correct answer. 20th question. As per section 2A of Copyright Act 1957, the limitation for adaptation does not include A, conversion of non-dramatic work into dramatic work, B, conversion of dramatic work into non-dramatic work, C, abridgment of literary work, D, translation of literary work.
I said does not include.
D, sir. Translation of literary work.
Yes, option
Does
D
not.
is the correct answer. Translation of literary work. The others include adaptation. All the remaining A, B, C. Only translation does not include adaptation. 21st question. The dramatic work as per section 2H of Copyright Act 1957 does not include A, recitation, B, cinematograph film, C, choreographic film, D, dumb show.
Sir, it should be
So,
D, I guess. Dumb show. Or recitation. A, sir.
Next option.
Recitation A.
B, sir.
Option B is the correct answer.
B.
Dramatic work.
cinematography.
Because cinematograph film is not a dramatic work. No? Recitation, choreographic work, dumb show, all these are dramatic works.
Dramatic work. Okay. Okay.
So cinematography film, that is a movie. It's not a dramatic work in the sense of Copyright Act 2H, section 2H. 22, next question. If a person or an organization holds the copyright on a piece of writing, music, etc., they are the only people who have the legal right to publish, broadcast, perform it. And the other people must ask their permission to use it or any part of it. The above statement is according to A, Copyright Act, B, Orient Longman's Dictionary, C, Chambers Dictionary, D, all of the above. So the answer is not here, sir, in this.
So none of the above.
No, all of the above.
In all of the above, sir.
Yes. All of the above give the same definition. Either the Copyright Act or United Longman's Dictionary Act or Chambers Dictionary. Then all of the above is the right answer for the 22nd question.
Okay.
Oh, sorry, not all of the above. Oxford English Dictionary.
Yes, yes.
Yes, sir.
It is
The
according to
definition which is
Oxford.
given is the Oxford English Dictionary.
Yes, sir. So option D, you make it Oxford Dictionary, sir. Or none of the above.
Yeah, none of the
Option D,
above.
none.
Actually, not all of the above. It is a none of the above is the right answer. Or you can make the Oxford University because you know it. If I give the none of the above, naturally that you will definitely click it because the first one I have to give none of the above. Later you have to give the other thing. Then I can confuse you. Otherwise, it's more better to give the Oxford Dictionary. Now you can say that it is in an Oxford Dictionary is the right word.
Yes, sir.
Next.
25th question. Which statement is correct among four? A. Words circulated on or after words created on or after January 1st, 1978 are not subject to renewal registration. B. As to works published or registered prior to January 1st, 1978, renewal registration is optional after 28 years but does provide certain legal advantages. C. For information on how to file a renewal application as well as the legal benefit for doing so. D. All of the above.
Sir, option A, sir. Works created on or after 1st January. No, sir. I'm getting confused. No idea, sir. Pass.
It is
D,
all of the above.
Yes. D, all of the above.
All of the above are correct.
So this question is very tricky, sir.
Yeah, that is critical. It is a critical one because unless until that you know the literature of it and you cannot make it out. But generally, as a sequence or logical reasoning is concerned, because the above one, the below one, it is not given the all of the above, then you can shoot the all of the above in such a case is there.
Yes, sir.
Sure, sir.
Okay, sir.
24th.
When was the first Copyright Act passed in India? A. 1846, B. 1847, C. 1848, D. 1849. We have already covered it.
Yeah.
B, sir. 1847.
1847.
Yeah.
It was the first Copyright Act when East India Company ruled us.
Yeah.
The first Copyright Act of India was enacted in 1847 during the regime of East India Company. As per the Act, the term of copyright was either for the lifetime of the author plus 7 years or for 42 years.
Yes, sir.
25th question. The first modern copyright law of India was A. The Act of 1911, B. The Act of 1913, C. The Act of 1914, D. The Act of 1918.
1914, sir.
Yes.
That is
It's
the
an
correct
act of
answer. Option C
1914.
is the correct.
Yes, sir.
The C is the
First
correct
modern
answer.
Copyright Act.
Yes, sir.
Next.
This is, I made some other thing. Criminal remedies, no, I think she cannot.
Then you move to next question, sir.
Yeah. Let us move to the next question.
The imprisonment, sir, that is there.
Is it? Let me check this. Again, acha, 1, 2, 3, that I told you to make it
Slightly
out because the style that you are making now,
Scroll down, sir.
it's taking me a lot of time to edit it. So I told you that you do in the fashion which you
my fault.
did it. Okay, read. Second question.
The imprisonment for infringement of Copyright Act 1957, A, can range from 5 months up to 2 years. B, can range from 8 months up to 2 years. Can range C. Can range from 6 months up to 3 years. D. Can range from 5 months up to 5 years.
Sir, option
The
C.
imprisonment.
C, sir. Option C.
Yes, option C is the correct answer. Can range from 6 months up to 3 years. That is the imprisonment for infringement of copyright. Next. The fine for infringement of Copyright Act 1957 is A. Ranges from 50,000 to 2 lakh rupees. B. Ranges from 50,000 to 1 lakh rupees. C. Ranges from 50,000 to 3 lakh rupees. D. Ranges from 50,000 to 5 lakh rupees.
Sir, 50,000 to 3 lakhs, sir. Option C.
Option A, sir.
Yes, option A is
50,000
the correct answer.
maximum.
Ranges from
50,000.
50,000 to 2 lakh rupees.
Option
Okay,
D,
sir.
correct.
Next, 26th question. Next question. Which section of Copyright Act 1957 provides for the inception of Copyright Board? A. Section 12, B. Section 11, C. Section 15, D. Section 16.
Sir, section 9, I guess, is not as far as my memory goes on.
It is Section 11. Option
Okay.
B is the correct answer. Inception of Copyright Board.
Okay.
Next question is, what is the term of broadcast reproduction right? What is the term for broadcast reproduction right? 10 years, 15 years, 20 years, 25 years.
I guess, yes, sir. 10 years.
Broadcast reproduction right is option D, that is 25 years.
Okay, sir.
Broadcast means through radio, through TV, etc., through net, like that. Through wire or wireless. 7. Which of the following is not a fair use of copyright work? A. Use for research. B. Use for criticism. C. Use for review. D. Use for commercial purposes.
Sir, use for review, option C. Or
Is
should
not
be
a fair use of copyright work.
should not fair use of. Okay.
Fair use.
Sir, D, sir, option D.
This option D is the correct answer. Use for commercial purposes.
Yes, sir.
Next. Copyright office is in A. Kolkata, B. Bangalore, C. Chennai, D. New Delhi.
A. Kolkata.
New
Next
Delhi, sir.
option.
New Delhi, sir. D.
Yes, option D is the correct answer. New Delhi.
It is under the central government, yeah.
Yes, with this, the role of the Kolikonda Sarath Babu is over. Now let me come under the dais. Yes, the PGL lesson 2022, the Patent Act of 1970, MCQ. The first question. Yes, first I want to scroll down so that you could not see my feedback. Oh. Okay. Who was the father of intellectual property right? A. Thomas Jefferson. B. Andrew Jackson. C. George Washington. D. John Adams.
George Washington, sir.
It is the George Washington is the right word because the feedback is George Washington was born on February 22nd, 1732. As we celebrate his 287th birthday, we remember him as the father of his country and father of the patent system.
Yes, sir.
Supplementary question. Just a IQ. George Washington is which prime minister? First, second, third, fourth?
He was the first president of United States of America.
I appreciate. Who was the right to patent? Who made it? Who has the right to patent? A. The inventor. B. The discoverer. The C. His heirs. And the last one is his essence?
Sir, option A, sir, the inventor.
The inventor definitely will
Obviously,
ask
the
for the
patent,
copyright, patent.
Yes, sir.
His heirs will definitely will ask for the patent. His assign is definitely asked for that. What is there which is discovered? Columbus discovered?
America.
America.
Is it an invention?
No,
Discovery, sir.
It's a
It's only
discovery, sir.
discovery. It's not an invention.
only patents or inventions.
A new thing which has come out, we call inventions. And who has the right to patent? The right to patent belongs to the inventor. His heirs, assignees. When two or more persons have jointly made an invention, the right to patent belongs to them jointly. Is it clear? Say yes.
Yes, sir.
Third question.
Yes, sir.
Yes, sir. Yes,
Who
sir.
is the youngest
Yes, sir.
patent holder in the world? I repeat. Who is the youngest patent holder in the world? A. Samuel Thomas Houghton. B. Houghton Samuel Thompson. C. Thompson Samuel Houghton. D. Samuel Houghton Thomas. Krishna Yadav, your home dialogue, sir, I could hear it. Shoot! Even though it is wrong. The youngest
Yes, sir.
patent holder in the world. The answer
Yes,
is
sir. Samuel Thomas.
Samuel Thomas Houghton. The A is the right answer. Samuel Thomas Houghton is the British inventor. In April 2008, at the age of 5, he received a patent for his sweeping device with two heads invention, and he is thought to be the youngest person to have been granted a patent for their invention. Supplementary question. What the first inventor has invented? The answer is sweeping device with the two heads. Is it clear?
Okay,
Yes,
sir.
sir.
Yes, anyone can unmute and read the fourth question.
Which
Which
Indian
Indian
state
state
has
has
the
the highest number of patents filed? A. Himachal Pradesh. B. Andhra Pradesh. C. Punjab. D. Madhya Pradesh.
Which Indian state has the highest number of the patent filed?
It's C.
Punjab,
Punjab.
sir.
The answer is C, Punjab.
Yes, sir. Punjab.
The next question, anyone can unmute, read with a loud voice, sonorous voice.
What is Patent Act in India? Option A, the Patent Act 1969. Option B, the Patent Act 1970. Option C, the Patent Act 1971. Option D, the Patent Act 1972.
Option B,
72.
sir. Patent Act 1970.
It is the Patent Act of 1970 is the right answer for that quote. Feedback is the Patent Act of 1970 is the legislation that till date governs the patents in India. It first came into force in 1972. Supplementary question. When the Patent Act of 1970 came into the force? Answer is 1972. The Office of the Controller General of the Patent Design and Trademarks is CGPD. TM is the body responsible for the Indian Patent Act. Now next question is, which company has the highest patent in India? Number 1, Google.com. B, IBM. C, Microsoft Corporation. D, Mesbo Technology. The highest
Should
patent
be
in
Mes-
India.
I think, sir, it should be Mesbo Technology, sir.
Wrong.
Google, sir. Google.
Wrong.
Then Microsoft.
It is the Microsoft. Can you tell me the one quotation of the Microsoft, Bill Gates? Can you tell me the one quotation of the Bill Gates? Say yes or no. Pass on. Are you hearing me?
Yeah, we can
Yes,
hear you.
yes, yes.
But why you are keeping quiet? You say pass on.
Pass on, sir.
Yes, sir.
Awesome.
The Bill Gates quotation is, if you born in a poor family, it is not your fault. If you die as a poor man, it is your fault. Did you get the point?
Yes, sir.
Yes, sir.
Good.
And he also spoke about procrastination, sir.
Next is, according to the report, Microsoft Corporation, Mesbo Technology second, SRM Institute of Science and Technology third, Meenakshi Academy of Higher Education is fourth, and research are the leading companies in the EdTech domain with the most number of the patent filing at count of the 12,964 respectively in India. The next question, which state recorded the highest in patent in India? Madhya Pradesh, oh, this is repeated already because we told that it. Next, read anyone. Eighth question, unmute and read with the sonorous voice. SONOROUS. Read loudly.
The types of patents are
You
Yes,
give
the
the turn.
patent.
Suppose if you read first, you give the chance to another one. If you read that one, you give the chance to another one. Yes.
okay.
Yeah, the types of patents are 3 but not 1 among them. Find out it. Utility patents. Option B, design patent. Option C, seeds patent. D, plant patents. Sir, it should be A, sir, utility patents.
If the utility patents are there, design patents are there, plant patents are there, then what is the answer?
Seed patents, sir.
Yeah, C patents are not clearly mentioned there. The ninth question. Patent protection is granted for a limited period in India, generally dash from the filing date of the application. A option 10 years, B option 15 years, C option 20 years, D option 25 years.
Option C, sir, 20 years.
It is the right answer. The 20 years the patent time is there. The 10th question. Indian Institute of Technology, IIT, dash filed a recorded breaking 107 patent over the last year. Which IIT? Option A, Kharagpur. Option B, Tamil Nadu IIT. Option C, Kanpur IIT. And the D, Bombay IIT.
It's option A,
Pass.
Kharagpur.
Repeat.
It's option A, sir. It's option
Pass.
A, sir.
Wrong.
Sir, option C, sir. Kanpur.
The right answer is option C, Kanpur. Kanpur is famous for what?
Kolhapur, sir.
Yes.
Leather
Geographical
companies.
identity.
Leather belts, leather bags.
11th question.
Major-
What was the first patent law passed in India? A. 1853 Act 4. B. 1854 Act 4. C. 1855 Act 4. D. 1856 Act 4.
Sir, it's Act 6, not 4, sir.
Yeah, sorry. I made a mistake. It is a 6. I appreciate your IQ, sharpness.
So
It is, I
1856,
think,
sir.
option D, sir.
Option B is the right answer. No. It is the answer is option D. 1856 Act 6. I repeat, it is 1856 Act 6 was the first patent law passed in India. Feedback. 1856 Act 6 was the very first piece of law relating to Indian patents. Because this act was passed without the consent of the British sovereign, it was abolished in the Act 9 of 1857. In addition, in 1859, provision for the exclusivity right were enacted. Supplementary question. When this act was abolished, Act number 9 of 1857, what is it to be replaced? It is the 1859 provisions are exclusively right were enacted. Supplementary questions. 12th question. Read anyone?
Who got the first patent in India on which date, month, and year? Option A, on 1st March 1856. Option B, on 2nd March 1856. Option C, on 3rd March 1856. Option D, on 4th March 1856.
On 1st
It's
March, sir,
option
option A.
D.
Wrong.
It's option D.
Wrong.
Option C, sir.
3rd March 1856.
It is the C is the right answer. That is on 3rd March 1856, the first patent in India is made it over there. 13th question. The person who got the first patent name, dash, and profession. A. Mechanical engineer, George Alford D. Penning. B. Civil engineering, George Alford D. Penning. C. Civil engineering, George Alford Cock. D. Electrical engineering, George Alford Cock.
The
Pass,
C,
sir.
civil engineer.
And he invented also that the machine fan.
Then it
Yes.
should be
The right answer is he is a civil
B.
engineering, George Alford D. Penning. He is from which place? George Alford D. Penning from the city. Which place from the city of India?
Kolkata.
Madras.
Bombay,
It's option B.
Madras,
Option D.
Kolkata, Varanasi.
Sir,
Kolkata.
option A, sir. Mumbai.
Wrong.
Okay.
Option B, Madras.
But somebody told Calcutta in the beginning.
Kolkata, sir.
It is a Calcutta is the right answer. He's a civil engineer, and George Alford, depending what he discovered is now a fan which is run with the machine. A civil engineer, George Alford, Penning G. Kant's Lane, Calcutta, petitioned the government of India for grant of exclusive privilege of his invention or an efficient pankha pulling machine. What is that he invented? Read. An efficient pankha. You know pankha?
Fan.
Yes, sir.
It's a
Fan,
fan.
sir.
Pankha means
Can you tell me how many types of the fans are there?
Sir,
ceiling
three, sir.
fans, pedestrian.
What are
Ceiling
they?
fan, wall fan, and floor fan. Pedestal
Pedestrian
fan.
fan.
Right.
It's pedestrian.
Then helicopter fan, aeroplane fan.
Domestic.
Right, sir.
Domestic.
Domestic international. Domestic
Yes, sir.
international fan.
Domestic.
Yes, sir.
Ceiling fan,
Commercial.
wall mounted fan, table fan, pedestal fan, exhaust fan.
Yes, sir.
Yes.
Right, sir.
I appreciate. 15th question. What is MCD, initialism, in patent? A. Matter classification database. B. Material classification database. C. Master classification database. D. Method classification database.
Sir, it's a master, sir. Master classification database. Option C.
You are right. It's the master classification database is the MCD initialism. It is one of the kind of the abbreviation. What are the other three kinds?
No, sir.
What are the other three kinds of the abbreviations?
No idea.
Number one, initialism. Number two, acronym. Number three, shortening. Number four, contraction. I told in the class. Is it?
Yes, yes.
Okay, 16th question. Who is the youngest patent holder in India? A. Gurgan Singh Bhati. B. Hridayeshwar Singh Bhati. C. Khalandar Singh Bhati. D. Ishwar Singh Bhati.
Sir, it's B, sir. He's from Punjab, I guess. He holds maximum number of patents.
This is Hridayeshwar Singh Bhatti B.
It is Hridayeshwar Singh Bhati is the right answer.
Yes, sir.
And what he patented, I did not know, but let us see that whether I give the feedback or not. He earned a patent for his invention in 2012, making him the youngest patent holder in India at the time. But what he patented, I did not make it out because supplementary question, what he patented, on what item he did it. Okay, next. 17th question. Okay, now supplementary question you will ask. Which is the tree which is useful for the 40 diseases?
OPM, sir.
I
That
said
is
which
neem.
is the tree which will cure 40 diseases?
That is neem tree.
Neem tree. In Kiswahili, we say neem tree, imti arbaini. Imti means tree, arbaini means 40. Imti arbaini means neem tree.
That's scientific name is Margosa indica.
Yes, you are right. 17th question. Who is the highest patent holder? Which country in the world? USA, option A, B, option Australia, C, option Japan, D, option India.
Sir, it should be Japan, sir, I guess.
It is a Japan.
Yes, sir.
Feedback is worldwide utility patent, inventors, patents, residence. Shrupi Yamazaki, 6041, Japan. Kia Silverbrook, 4747, Australia. Kangwo Chang, 2605, USA. Level L Wood, Junior, 1978, USA. These are the sequence. Now, 18th question. Who grants IPR in India? It is the CGPDMT, B, CGDPTM, it is a GCPDTM, is it a CGPDTM, which is the correct initialism?
Sir, it should be CGPDTM.
Yes, you are right. It is CGPDTM. That means the intellectual property in India is administered by the Office of the Controller. C means controller, G means general, of patent, P means patent, D means design, and that is symbol and. In the Latin terminology, we will say ampersand. T is for trade, M is for marks, within parentheses, CGPDTM. This is a subordinate office of the Government of India and administer in Indian law, patents, designs, trademarks, and geographical indications. Like I told you, geographical indications, Kolhapur Chappal.
Yes, sir. Kolhapur.
Okay, now let us see that I would like to ask you, because I don't want to give the chapters. How many chapters are there in the Patent Act of 1970? How many sections are there in the Patent Act of 1970? How many schedules are there in the Patent Act of 1970? I am not giving the option. I would like to know. Yes?
Means 23, sir. 23 chapters are there, sir.
How many sections?
Some around 160, sir.
163, but the last section is repealed. 162 is the saving clause.
Okay.
How many schedules?
23, sir.
Schedules are only one. The Patent Act
Chapters
of
are 20.
1970. 20th question. The Patent Act 1970 and the Act number dash of 1970. The Act number is A 37, B option 38, C option.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
We live in a world full